The last case on the docket is also from Sedgwick County. It's 127-556, entitled The State of Kansas versus Juan Torres. Talent, we have
Mark Siebert, court-appointed counsel.
for the appellee.
May it please the court, Assistant District Attorney Christiane appears on behalf of the state of Kansas.
Mr. Siebert, do you wish to reserve any time for rebuttal?
Yes, Your Honor, if I could reserve 5 minutes.
That is granted.
Thank you.
You may begin.
Thank you, Your Honor. My name is Mark Siebert. I'm been court-appointed to represent my client in this case. And appreciate you all coming here to Sedgwick County to hear these cases. Judge Malone, it's certainly good to see you. Miss you and your trial work here in Sedgwick County. This case I find a bit troubling. I recognize that the factual aspects of it are troubling in themselves, but I can't help but think about some of those cases where an American citizen goes to some country, commits a crime, and then gets locked up forever. And everybody back here thinks, oh my gosh, what a tragedy. What kind of system of justice do they have over there? And all of those. And this was an individual who clearly was not an American citizen, was involved in a situation that is horrific in facts, but, and that's assuming, I mean, that they're all correct. The situation is he has broken English, somewhat broken Spanish, and is given a court-appointed attorney and is basically led to the podium to plead no contest in the hope that he might be able to get some sort of lenience from the court and then be sent back to Mexico where he's got some family. And the problem is that, and it really was unfair even to Judge Torres, who does a great job, but he wasn't given any information to make some sort of a departure back onto the grid.
He had an interpreter, did he not? That was adequate?
The defendant did have an interpreter, yes.
And no complaints about that, about the adequacy, sufficiency of the interpreter?
That, I have not raised that. I think any issues that may have been going on there was probably more of a situation of intellect or what he was being told. I think he understood what the interpreter was saying, except for the fact that he went to the podium with the plea thinking he was facing a 55-month sentence, already having served a big chunk of that, and that he was going to be deported back to Mexico.
At the plea hearing, did the district court judge advise him of the maximum penalty for the crime?
He did.
So he was advised that this could involve
A life sentence, yes, yes. I think that, you know, and I recognize that, you know, with respect to some of the factual findings, it's abuse of discretion, but with respect to some of the legal issues involved here, you have unlimited authority and review. And I think some of the legal issues here to be considered are, was his attorney effective? Was it lackluster representation? I think also how does unconscionability or lack of consideration affect a plea negotiation? You know, I know we use contract law to kind of guide us through plea negotiations, but this gentleman, unfortunately, was in a worse position by entering a plea than he would have been if he'd gone to either a bench trial or a jury trial. I mean, I more than once I've had to try a case I'd rather not be trying because the cards seem to be stacked against me. And then we get in the courtroom and I don't know, some witness testifies something completely different than what they told the police, or a different jury panel shows up, or, you know, all kinds of things can happen. But the situation we run into is that there needs to be some consideration for waiving all of your constitutional rights and putting yourself in a position of subjecting yourself to a life sentence, especially, you know, at a young age. And there just wasn't any consideration. I think his attorney said, well, he was allowed to argue for a departure. Well, he would have been able to argue for a departure if he'd been convicted by the jury. He actually, like I said, by pleading guilty, gave up all of his constitutional rights, gave up all of his opportunity to confront any of the witnesses, and probably more importantly, gave up any ability to kind of educate the judge on what the facts and the circumstances of this case were. And that
You could at least argue for acceptance of responsibility by pleading. That's at least one small benefit that he could say he received. Is that right?
That is correct. Now, in federal court, you actually get some points taken off of your sentencing by accepting responsibility. We don't really have that here in Sedgwick County or in the state of Kansas. But I think acceptance of responsibility still has to be followed up with substantial and compelling reasons for the judge to depart by putting the case back on the grid. And I think they just threw this in front of Judge Torres and said, be a nice guy and put him on the grid. And just so you know, he's going to be deported as soon as this is all over. And I don't blame the judge for thinking, well, wait a minute, maybe I need a little more information. I would submit that, you know, a problem for this Mr. Torres is that if he, you know, had gotten a 55-year sentence or 55 months sentence and been deported, he'd probably have some family back home to go to. Unfortunately, if he does this entire 25 years, by the time he gets deported, he's probably not going to have anybody to go home to. And so there's just an awful lot on the table here that was never even looked into.
Didn't the trial judge hold an evidentiary hearing on this motion and find the defendant's credibility was weighted against him?
With respect to actual innocence, yes. And I think the judge took into consideration, I mean, there wasn't ever a trial, so I'm not sure what all evidence the judge was basing that on other than the quality of the plea. There was this letter that apparently the client had written apologizing to the people involved, and that was being construed as a confession. And I don't know, I mean, people all the time apologizing for a car wreck or apologizing for this, that, or the other, and that doesn't mean they're accepting legal responsibility for it. It could be just, I'm just really sad that the relationship has been destroyed by this. You know, there was also some information about how this client had been abused himself, and we see that all the time, where people who are abused then go on and abuse. And you know, I think it's important that we have you know, protections and so forth for people who are being abused, but we also have some obligation to yesterday's victim of abuse, and then to just throw them in jail forever. That just doesn't seem very American, I guess. I think that the situation that we have here is that there could have been more aggressive defense work. There could have been better presentation of sentencing information to the judge. I think that he was taken advantage of. You know, he was told you need to plead guilty or you have absolutely no defense. And I just submit that was bad advice, and that was taking the easy way out. And that if you really are going to try to bet against the state and roll the dice on something like that, you better have some pretty substantial and compelling information. And that was just never developed. I think that as a matter of law, the court could find that there needs to be at least some consideration in a plea negotiation in order for it to be carried out or enforced. And that there just simply wasn't any here, and that it would be unconscionable for especially a person of foreign descent to give up every single right and throw it on a court without any real backing. That's just not going to work. And so I think he was suckered into believing that he had a 55-month sentence, and the reality is he's sitting and looking the rest of his life in prison. And, you know, you know, on the strength of the underlying case, you know, we're not here on that to the full extent, but even at the plea hearing, he did at one point plead not guilty, and then they had a little recess, and then he said, I meant no contest or something to that effect. In some of his pro se filings, he was again arguing about actual innocence, but we never really got to that level because of, you know, of the plea and trying to get that. This was a joint collateral attack of the you know, post judgment attack. It was both 1507 and a motion to set aside the plea, but I think you'll know that. But anyway, any other questions at this point? Well, I appreciate it.
You still have your rebuttal.
Thank you.
Good morning. Ben Christiana appears on behalf of the state. First of all, I think it's important to remember the standard of review when we talk about a post-sentence motion to withdraw plea. My colleague keeps saying lackluster advocacy, but as we know, post-sentence motion to withdraw plea, there has to be it has to be viewed in the light of the competent counsel, which is that counsel's performance fell below a reasonable standard. And that there was a reasonable probability, but for counsel's performance, the defendant would have insisted on going to trial. And as this court knows, the Supreme Court has said that there is a strong presumption that counsel's conduct falls within a wide range of professional assistance. So what we have to look at is deficient performance as far as what was alleged in the briefs was that counsel spent limited contact with him. The record will set forth that counsel spent 30 to 40 minutes before the plea hearing with the interpreter and the defendant. Additionally, before the preliminary hearing, counsel made a record that the court was very generous with its time in allowing counsel and the defendant and the interpreter to go over the information. So the record does not support the allegation that there was limited less than 15 minutes of time spent with the defendant and counsel. As far as counsel's performance, taking this to trial, counsel testified that he was provided witnesses. He attempted to find those witnesses. The witnesses he found were either uncooperative so the witnesses he found were uncooperative. Other witnesses he's unable to locate. Additionally, you have that counsel recommended a plea, and Mr. Sievert thinks that this defendant was suckered, I believe is the term that he used. Counsel was very clear in his testimony that he explained to the defendant multiple times, you are not guaranteed a departure. And in the plea agreement, the court even told him, you understand that the court is not bound by this agreement. The court can enter any lawful sentence and impose any lawful sentence. The defendant understood that.
So with the plea agreement, what did the state agree?
The state agreed to, for the defendant to plead no contest as charged, that he would be free to argue, which yes, he would have been free to argue the departure had he gone to jail and been convicted. But again,
So the state never said we jointly agreed to depart to the agreement.
No.
So there's no agreement in terms
no, there was not.
on the plea agreement suggesting anything but a life sentence, but you're free to argue for departure.
Correct.
So
And
what was the benefit to the defendant of the plea agreement?
well, the benefit, as his plea counsel testified, was that if he accepted responsibility in front of this judge that was untried on departures in Jessica law cases, that counsel thought that this was his best ability to potentially get a departure. And counsel explained that he had a case before this same judge. It was not a Jessica's law case. He had a case where the judge granted a departure over the state's objection. And so he thought, given this apology letter that counsel discussed with the defendant and how that affected their case, he felt that the best way to do this was in front of this judge, accept responsibility, and that would make the best argument for departure.
He really didn't accept responsibility, though, did he?
He did not. He pled no contest. And he disagreed with the factual basis. But again, there was this discussion. And I guess what I would say is it appears that Mr. Sievert has an issue with a plea guilty as charged. we all know that there are plea agreements. Plead guilty as charged. In this case, it was no contest, plead no contest as charged. So this was not something that the defendant had to take. This was not a forced upon him agreement. He could have gone to trial. But it was by the recommendation of his experienced counsel that the best way, I believe, that you are not going to spend the rest of your life in jail is for you to take this plea and then we'll argue to the court. And just because he didn't get the sentence that he wanted does not mean that there was not consideration. It does not mean that he did not get a benefit from that plea. Further, as far as
What consideration did he receive? Stay.
what consideration did he
I mean,
receive?
free to argue departure, that's, you don't have to have state's agreement on that.
No,
What
you
did the
don't.
state, what did the state give in return in this plea?
I don't know that the state has to give something in return.
Right, so they did nothing. So it's basically, you're charged with the Jessica's law. I'm not,
No, yeah, I
I'm
understand.
just setting the record straight. He was charged with Jessica law, one offense,
Yes,
and he pled as charged.
yes.
That's it.
Right, so I guess my position is that you don't have to, the state doesn't have to give consideration, right?
Correct.
So benefits that he received are also that the facts, the specific facts of what he did in this case were not put before the court. There was a motion for 6455 evidence regarding prior acts of this defendant that was not put before the court.
See, that was gonna be part of it. If you go to trial, all that.
Correct, correct. And as plea counsel testified, he felt the victim was a strong witness. He knew that 6455 evidence was coming in. The defendant did not have witnesses coming in to testify on his behalf. So he felt that this was the best way to potentially get the sentencing judge to give him some grace and grant this departure. As far as it being unfairly made, again, he didn't have to accept it. I think we've gone over what the consideration was, the reasons for why he would have accepted or would have accepted the plea agreement. He was not misled. Again, the focus seems to be on he was promised departure. The record sets forth that he was told multiple times he may not get a departure. So at this point, I would submit that there was no deficient performance by counsel. There was no prejudice by counsel. The defendant was not misled that he would absolutely be granted a departure. It was fairly and understandingly made. He was discussed multiple times with an interpreter. He did not have to accept the plea agreement. He could have taken it to trial, but based on counsel's experience, he felt that this was the best thing for his client. If there are no further questions, the state would just ask this court to affirm the district court. Thank you.
Police court, there was no consideration by the state. And I would submit that plea negotiations are governed in a manner consistent with contract law. And contract law clearly requires consideration in exchange of promises, something in exchange for something else. And the consideration that was presented here was dangling something in front of them that was worthless, made to look good, but it really was worthless. And it you know, from back in my consumer fraud days, I would have called it bait and switch. You know, he was baited with this 55 months, you're gonna go home and see your family, to, no, we're gonna lock you up forever. And that just strikes me as a violation of due process and a violation of constitutional law, and violation of plea negotiation law. The state just didn't give up anything. And I think the error, the legal error that his attorney perhaps made, and I'm not here to badmouth the judge or the attorneys or anybody involved, but is when you have to be able to demonstrate substantial and compelling reasons to depart, even to depart back onto the grid. Acceptance of responsibility in and of itself, I would submit, has not been found to be substantial and compelling. And even outside of that, it still leaves so much discretion to the judge. And when you're in kind of a nasty case like indecent liberties or aggravated indecent liberties, it's extremely difficult on a district court judge to go out on a limb for somebody without some pretty good information being in front of them to rely on. And a lot of times, acceptance of responsibility together with the district attorney's office agreement to the departure, that is pretty substantial and compelling. But when the DA is sitting there and hadn't had to do any work whatsoever, except threaten to use this information or that, there just wasn't any consideration. And quite frankly, I would submit it may have been better for the judge to have heard all of the story, not just the allegation. That perhaps I would have developed information for another departure basis of that the acts in this case were not as substantial as they might have been in, the ordinary run-of-the-mill aggravated indecent liberties case, or that there maybe was a relationship between these parties that was a little bit different. We don't know because there was never a trial or an opportunity to develop any of that. I can tell you, I've dealt with 6455 motions, and in sex cases, it's a bad rule. They can pretty much let in anything they want. But defense counsels can also sit there and say, all that information, it's really just, rolling the twine. All they're doing is just adding more allegations on top of more allegations and hoping that you convict somebody based on allegations. Or you can also argue, makes this guy a pretty easy target to, accuse him of doing something because everybody knows his past. And so, it's not a dead end road simply because they may get some 6455 evidence in. The thing that I just keep getting troubled about is we have a foreign citizen come in here, not given a whole lot of legal advice other than throw yourself on the mercy of the judge, and then nothing given to the judge to help improve the mercy, and then sent off to prison. If that was an American citizen in Mexico or American citizen in Russia or in China or something, we'd be figuring out how to set up a GoFundMe page to get somebody to go over there and get them, or be talking to politicians about going over there and doing a prisoner swap. It's just troubling that, regardless of what, thank you, regardless of what the crime is, to kind of bait somebody into a life sentence. Thank you.
All right, counsel, thank you very much for your briefs and your arguments. You both did a very fine job on this case. As I mentioned, we'll take the case under advisement and get an opinion out to you as soon as we can. And with that, this morning's hearings are completed, and so court is adjourned.